Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts This Week on Live Law, where we update you about all the important legal developments that took place across the country last week. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, then please do not forget to like and subscribe to our YouTube channel. Let's begin. The Supreme Court has held that a son or daughter adopted by the widow of a deceased government servant after the death of the government servant cannot be included within the definition of family under Rule 54 Clause 14 Subclause B of the Central Civil Services Pension Rules to claim family pension. The definition of the term family cannot be extended to include those persons who are not even dependents of the government servant at the time of his death, the bench of Justices K.M. Joseph and P.V. Nagaratna observed. A constitution bench of the Supreme Court of India has commenced with the hearing of reference which pertains to this particular issue, that is whether the arbitration clause in a contract which is required to be registered and stamped but is not registered and stamped is valid and enforceable. On a previous occasion, a 5-judge bench comprising Justice K.M. Joseph, Justice Ajay Rastogi, Justice Anuradha Bose, Justice Hrishikesh Roy and Justice C.T. Ravikumar had passed directions to appoint senior advocate Mr. Gaurav Banerjee as an amicus curiae to assist it in hearing this particular matter. Last week, the Supreme Court of India directed a batch of applications seeking inter alia an enhancement of the number of seats reserved for promotion to higher judicial services through a limited departmental competitive examination and the reduction in the requirement of 10 years minimum qualifying service to 7 years for successful candidates. A division bench of the Supreme Court comprising Justices B.R. Gavai and M.M. Sundaresh was hearing a writ petition pertaining to the members of the subordinate judiciary which have already travelled through several rounds of litigation before the Supreme Court and resulted in the issuance of a spate of directions for the betterment of service conditions of judicial officers across the country. The hearing in the case in the Supreme Court between the central government and the Delhi government regarding the administrative control over transfers and postings of civil servants in the national capital took an interesting turn last week, with the central government seeking a reference of the matter to a larger bench at the very fag end of the hearing. A 5-judge bench led by Chief Justice of India D.Y. Chandrachud has been hearing the matter since January 10th. Senior advocate Dr. Abhishek Manu Singhvi completed his arguments for the Delhi government, and Solicitor General of India Tushar Mehta made arguments on behalf of the central government over the last few days. However, when the matter was posted for the rejoinder arguments by Dr. Singhvi, such a request by the centre was put forward before the bench. The Supreme Court of India has refused to interfere with the order of the NCLAT, which refused to stay the order of the Competition Commission of India, that is CCI, which had imposed a penalty of Rs 1,338 on Google India for abuse of dominance in relation to the Android ecosystem. However, the Supreme Court of India last week directed the NCLAT to dispose of the appeal filed by Google by March 31st this year. In a first, the Supreme Court Collegium has put on record the reasons to reject the objections raised by the central government to recommendations made regarding judges' appointment. The Supreme Court Collegium reiterated the names of 5 advocates for elevation to various high courts of the country. However, while reiterating these names, the Collegium comprising Chief Justice D.Y. Chandrachud, Justice Sanjay Kishan Kaul and Justice K.M. Joseph gave express reasons for discarding the objections raised by the Law Ministry. What is significant in this move is that the Collegium has also published these statements with the reasons, which is unprecedented. The Supreme Court has issued notice in a special leave petition filed by employees of Air India Limited against the judgment of October 20th last year of the Bombay High Court, which had held that writ petitions are not maintainable against the airline because of the subsequent privatization of Air India Limited. The SLP was listed before a bench of Justices B.R. Gavai and Vikram Nath on 16th January. In a significant ruling, the Supreme Court last week held that police and investigating agencies like the CBI, ED cannot be directed to upload charge sheets filed in cases in a public platform for easy access by the general public. A bench comprising Justices M.R. Shah and C.T. Ravikumar held so while dismissing a PIL filed by RTI activist Saurav Das. The Supreme Court bench termed as misplaced the reliance made by advocate Prashant Bhushan on the Supreme Court's judgment in the Youth Bar Association case, in which directions were issued to the police to upload the FIRs in the website within 24 hours, except in sensitive cases like rape and sexual offences. The Supreme Court of India has heard filmmaker Leena Manikalai's plea challenging the multiple FIRs registered against her in various states over the poster of a documentary titled Kali. This particular matter was listed before a bench comprising Chief Justice of India D.Y. Chandrachud and Justice P.S. Narasimha. The bench, while issuing notice to the state, directed that no coercive steps shall be taken against the filmmaker either on the basis of the FIRs which have already been registered or on the basis of FIRs which are yet to be registered pertaining to the Kali poster row. The Bombay High Court has rejected a petition filed by Rapido, a bike taxi aggregator, against Pune RTO's refusal to grant it license for plying 2- and 3-wheeler taxis. A division bench of the High Court pertinently pointed out that there are discrepancies in Rapido's stand, as on one hand it is saying that license cannot be rejected on the ground of the absence of state policy on 2-wheelers, while on the other hand it cites the absence of a state policy for non-compliance with the Motor Vehicle Aggregators Guidelines 2020 issued by the centre. The Kerala High Court has allowed anticipatory bail applications of former police and intelligence bureau officers, including former Gujarat ADGP R.V. Srikumar and former Kerala DGP Sibi Matthews, in the case relating to the alleged framing of former ISRO scientist Nambi Narayan in the 1994 ISRO espionage case. A bench of Justice K. Babu passed this particular order. The court directed that the accused must appear before the CBI for interrogation on January 27th. The Calcutta High Court has ruled that infertility of a woman cannot be a valid ground for seeking divorce. The court also underscored that asking for divorce by mutual consent from one's wife, who is in a traumatic situation for having developed primary infertility, amounts to mental cruelty within the definition of Section 498A of the IPC. Empathizing with the wife's medical condition, the court acknowledged that primary infertility caused due to premature menopause is a great mental shock for a woman who is yet to become a mother. Thank you. Keep watching Courts This Week on Live Law for more such updates. See you next week.